QC, right, and my buddies Masum and Khalid, who put all of this together. What I'm going to do today is to speak to you a little bit about the... Can you hear me? Sorry. Can you hear me now? Is that better? Sorry. Okay, what I'm going to do for you today is talk about possibilities, not the challenges. The rest of the panelists have spoken about challenges, and those are things that are more legalistic in nature. Things that only you practicing here in Bangladesh would know how to handle and tackle. What I'm going to do is I'm going to speak a little bit about possibilities. And to start off here, I could just read something from this book. I just saw this book here, the Arbitration Act 1 of 2001, right? 2001's this thing, and this is the 4th edition. The preface to the 4th edition says this: in today's world, where we are greatly dependent on the free flow of trade and investment, arbitration is one of the most common ways of settling a dispute between parties without having to recourse to the time-consuming, costly, and complicated procedure of litigation. All right, what I want to show to you is two things. One, what arbitration should be like, and how you can get to that stage of taking arbitration to that level. And second, slightly more important to what I practice, is what is called appropriate dispute resolution. It is not alternate, it is not additional, it is what is appropriate in this economy and this state. And why do I say that? If I may just quickly summarize, we have things like conciliation, negotiations, mediation, which are all consensual dispute resolution mechanisms. And we have adversarial dispute resolutions like neutral evaluation, expert determination, adjudication, dispute boards, arbitration, and then litigation. And arbitration is fifth on the line of all of these adversarial dispute resolution mechanisms. All right, so keep that in the back of your mind. A brief about what we do in Singapore starts from, first of all, this. It's been recognized that Singapore is now the 3rd most popular arbitration seat, ranked after London and Paris. Last year, 84% of the new cases filed were all international in nature in Singapore. Large portion of the non-Singaporean parties originated from India, China, with India consistently ranking among the top 3 for the last few years. But in 2018, we saw the USA top as the foreign user of arbitration in Singapore. So can you imagine that? We had from Asia, India, and China. If you ask why, very simple. The Chinese consider Singapore China, all right? And the Indians consider Singapore far better than Hong Kong. So you have these two countries coming to Singapore to arbitrate. And yet, in 2018, one of the most number of arbitrations held in Singapore was from the US. So how did that happen? It's because we've got in place a regime and a set of rules and procedures that encourages everybody to come to Singapore to arbitrate. All right, and some of these things include what the Ministry of Law does. They implement acts and they amend the acts to move it forward thinking towards what the commerce requires. At the moment, Singapore is in consultation with the public on amending the International Arbitration Act, and the kind of things they're looking at is to introduce a default mode of appointment of arbitrators in multi-party situations, allow party by agreement to request the arbitrator or the arbitrators to decide on the jurisdiction at a preliminary stage as opposed to at the full hearing, recognize that the arbitral tribunal and the Singapore High Court has power to enforce obligations of confidentiality in arbitration, because issues of confidentiality does have problems sometimes. These are some of the recommendations they're looking at. Allow a party to the arbitration procedure to appeal to the Singapore High Court on a question of law arising out of the award made in the proceedings, and provided that parties agree to that. Right? So they're allowing for some form, not an appeal, but a review, right? What else are they doing? A proposal to allow parties to agree to waive or limit the annulment grounds under the model law. That means, take away, the model law has got certain ground rules, to bypass those ground rules if parties agree to it, all right? So these are this is what the government is doing in their consultation with the people, and you notice the key word is a consultation with the people. They're consulting with the practitioners to see what they think is practical in moving forward. All right? Now, there are also investment treaty arbitrations that have been doing really well in Singapore, and the reason for that is because the courts take a position that they are pro-arbitration, right, and pro-investment and so on and so forth. So they don't impose our strict Singapore regulations or Singapore procedures on a international arbitration that comes to court, right? So the point of that is this. Some of you may be familiar with the model law has got these public policy defenses that are available when you're enforcing an award in a foreign country. Singapore's attitude is very simple. If the arbitration was carried out in a country where the rules and practices or the business environment is such that they practice those kind of things, right? Then Singapore is not going to impose its strict values on that decision because in that particular country, they follow that system. So let's say, for example, hypothetically, that there is a system in place where money transacts before the contract is entered into. You can call it whatever you want, but I'm just saying money transacts before the contract is entered into. You can figure out what that means, right? Singapore is not going to say, because it's against our corruption laws, we will not apply it. What Singapore will say is that because it's practiced in the country where this arbitration was held, parties have agreed that that's where the seat of the arbitration should be, the rules of the arbitration is supposed to be from that country, so we will not impose that by setting aside the award. So you find that Singapore does this, a very proactive approach to arbitration and arbitration decisions that are made overseas. All right? Then, moving on from just arbitration, pure arbitration itself, when I mentioned to you about ADR being appropriate dispute resolution, Singapore has got two very important things. The Singapore International Commercial Courts. That is a court that allows you, if parties agree, to have your dispute resolved in the Singapore courts. It's the international court, but whether it's from a civil country or a law country, both countries and their laws can apply in the case that they're dealing with, and they have international judges that are dealing with it. All right, so this gives international parties an opportunity to move further, move beyond just arbitration. And just recently in August, we signed the Singapore Convention. The Singapore Convention allows international mediated settlements to be enforced internationally, like the way the arbitration awards are enforced under the New York Convention. So you see, what Singapore is doing is that they set in place a system that facilitates international organizations coming and fighting their matters in Singapore, whether it's through arbitration, whether it's through the international courts, or whether it's mediation that's settled and then enforced. All right, so you have that scope of things that are in place. Now, if you take a look closer to the arbitration framework itself, you have legislation that is constantly moving in Singapore. We have the International Arbitration Act that are applicable to international arbitration. We've got the Domestic Arbitration Act, which is called just the Arbitration Act. Insofar as the international is concerned, it sets out clearly what an international parties to arbitration means. There are amendments that have been recently made, like for example, Section 2A of the International Arbitration Act talks to you about what an arbitration in writing means. You have emergency arbitrator appointments under Section 2A of the International Arbitration Act. It has been amended to include an emergency arbitrator to hold an arbitral tribunal in an emergency matter, in a matter that needs a quick decision in a short time frame, right? QCSA had just mentioned to you the expedited means of arbitration. We have that in Singapore, that you can move along in arbitration and have it settled within 6 to 8 months. I had an arbitration recently that we just wrapped up last week before I left for Delhi. It was a coal mine arbitration. It came to me in February this year when the notice of arbitration was served on us. My clients were from Indonesia, the claimants were from Dubai. When it was served, the notice was served on my clients straight away told me they have no defense and they have no idea what to do. I said, come to me, let's see what we have. We filed a response to the arbitration The minute we filed the response, the claimants called me up and asked for a meeting to see whether we could resolve the matter. We held a meeting in June, we made a proposal, they didn't want to accept it, and then the process started and an arbitrator was appointed from Germany. And just last week we wrapped it up and we're asking the arbitrator to sign off on a consent award. So you see the interplay between, and it was a mediated settlement, so to speak. So you see the interplay between the different forms of dispute resolution mechanisms that take place. The Singapore courts as well, very unbiased, very pro-arbitration. As far as an arbitration comes to court, they will stay court proceedings. Here you say that it is not, what is the term you used when you talk about writ? Your writ is when you have an arbitration, non-maintainable, right? I find that a little difficult to appreciate, because I think the layperson may think that you have no right at all. But in Singapore, what we call it is a stay of proceedings. So it doesn't mean that you have no right or no claim. It's just that court proceedings are stayed in favor of arbitration so that they are dealt with first. And if it cannot be resolved or there are avenues for you to work around it, you can still come back to court. All right, so therein lies a slight difference. Appeal. In Singapore, you can't, the domestic arbitrations you can appeal, the international arbitrations only on certain restricted grounds can you appeal. The reason for that is they want to encourage people around the world to appreciate that if you're coming with your award and you want it enforced in Singapore, we are going to allow it. We are going to follow through with it. All right. There are certain other rights under the Singapore International Arbitration Act, but the essence of this, we will talk a little bit more during the Q&A. But the essence of it is the possibilities. The possibilities are basically setting the right framework from the government, from acts that are passed in Parliament, setting a right framework of institutions, which we will discuss in a while about the Singapore International Arbitration Center and in the region, the Asia International Arbitration Center, what they do. And the judges and in the courts taking a stand that is very pro-arbitration. And then you need really trained and qualified people who practice arbitration. And that is very critical. Just 2 days ago, I was in India and we were doing a moot competition for university kids. It was a arbitration, mediation, moot. Meaning you start off with an arbitration, you stop, and then you go into mediation. Now the interesting thing was this. Several of us judges came in on the quarterfinal stage and we were briefed on how to assess the students. And then I saw this blank look on the judges. And then I just turned to them, there were about 6 or 7 of us, and then I just turned to them and said, would you like me to explain to you what mediation means? And then they said, yes, please. So I had to spend 10 minutes describing to them what mediation was. Now the point of that matter is this. You're asking these same people who have no clue about mediation to judge mediation. How is they supposed to do that? So it's very critical that you get the right training here. And the right training starts from arbitration training, fellowship training, award writing trainings. And if you have a good set of arbitrators, you find the level and the quality of your standards going up. And before you know it, it trickles upwards or it trickles downwards. Trickle upwards meaning that the qualified arbitrators will take the position to the judges will look at it more favorably, the judges will take it up to the ministries will look at how the acts can be amended and changed and developed over time, and you find the whole process set in frame. Now in the Q&A we'll talk a little bit more about why Singapore has been so successful in how they go about doing it. So just understand, my aim was just to talk to you about the possibilities. The challenges are challenges that every country faces in the court system when they face the cases, but those are very specialized areas of arbitration. So with that, I'll stop here and then we can deal with the Q&A. Thank you.